Before our esteemed guest of honor addresses the august audience, I have the privilege to briefly introduce His Lordship, Honorable Mr. Justice Kurian Joseph, former Judge, Supreme Court of India. His Lordship's illustrious legal career began with his LLB from Kerala Law Academy, Thiruvananthapuram, and subsequent enrollment as Advocate Kerala Bar Council in 1979. His Lordship was appointed to various prominent posts such as Government Pleader for Government of Kerala, Additional Advocate General Government of Kerala. He was also designated as a Senior Advocate in the High Court of Kerala in 1996. In 2007, His Lordship was appointed as a Judge of the Honorable High Court of Kerala. In 2010, His Lordship was appointed as Chief Justice of the Honorable High Court of Himachal Pradesh. His Lordship was elevated as a Judge of the Honorable Supreme Court of India in 2013, where His Lordship served till his retirement in 2018. His Lordship has successfully completed the Specialist Mediator Workshop at Singapore International Mediation Center. His Lordship has been appointed as a mediator in several cases by the Supreme Court of India and other high courts such as the High Courts of Delhi and High Court of Sikkim. His Lordship is also the panel member of Delhi International Arbitration Center, Arbitration and Conciliation Center, Bangalore, in addition to Bombay Chambers Center for Mediation and Conciliation. His Lordship is also the visiting faculty for National Judicial Academy of Bhopal and other judicial academies of other states. It's now time for our guest of honor's address. May I request His Lordship to address us on origin, development, and effectiveness of mediation.
Thank you for the brief introduction. Mr. Deepak Parekh, the chief guest of this function to mark the 183rd General Body of the Bombay Chambers. Mr. Sunil Mathur, the President, and Mr. Parthasarathy, the incoming President, who has given us a statement of mission with a vision, and Mr. Vijay Srirangan, the Director General, and my dear friends from the world's largest chamber of commerce in both industrial and corporate sector. I'm really honored in having been invited to speak to you in this General Body meeting on a technical subject. But I'd just like to comment on as a brief comment on the vision statement. Corporates for Change, and Mr. Parthasarathy has quoted Mahatma Gandhi saying that you should be the change that you want to see in others. So the Bombay Chamber should lead. And what is this change? He has actually given the 4 action plan also. But it's with the vision. And vision is Bombay Rise. And it's actually Bombay rises, as Mr. Deepak Parekh has been now mentioning, India will rise. If you know something about the Constitution of India, I'm sure many of you know also, we have something called fundamental duty. One of the most important fundamental duties in the Constitution is to strive for excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement. So in this striving for excellence in all spheres of corporate and industrial activity in Bombay, I'm sure will make India rise. And once India rises, it will shine. So rise and shine should be the ultimate goal of the Chamber of Commerce of Bombay. That's my humble request to all of you. Because once you rise and shine, that is the shining face of India domestically and internationally. I wish you all the best. Now coming to the topic allotted to me, that is on mediation. If you see the origin and development of the Industrial Disputes Act 1947, we had earlier statutes also. Those were all times when there was no industrial peace because of the labor unrest. That is the only reason. Now, we don't hear much of a labor unrest now. You don't find I don't think the past 10 years there has hardly been any lockout or layoff on account of labor unrest. Well, in the past 3-4 decades, probably the whole trouble with India's economic growth in the industrial sector, the stampeding block was the labor unrest in the industries. That phase is gone now because we have a new labor phase for themselves and for the industries also. And I do not think that there is any labor unrest in the corporate sector because there's a new labor culture there, of which the workmen are also aware and the management also is well aware. So what is the problem now? Problem intra is over as far as India is concerned, according to me. And particularly coming from a state of origin of Kerala, and having been in the legal field almost 19 years as a judge and 20 years as a lawyer, 40 years now. And Kerala and Bengal probably witnessed most of the labor unrest. Those were all problems intra. Now we have problems intern. This is where the role of mediation comes. Once you have no problem intra, then the next question is how to take your industry or corporate sector forward in relation to your corporate affairs or other contractual affair, commercial or trade activities domestically or internationally. And we have a lot of contracts internationally also and domestically also. As was mentioned by Mr. Vijay Singh and also Mr. Sunil Mathur, probably now a new phase has come. Instead of arbitration, primarily you will have to try for mediation also. Why? The reasons I'll tell you briefly. Well, let me just trace the whole scenario as to where this come from. This mediation is a culture of India originally, but it had its shape legally in the framework of Section 89 of the Civil Procedure Code. Section 89 was amended on account of the large pendency of cases in India and the bad name India has, that once you invest in India and once you naturally or probably you may have some dispute, it might take long years. Nowhere in the world you will find this much time that is consumed in courts for settlement of disputes intra or inter the corporates or the industries. So therefore, India thought of amending the whole procedure of litigation. There was a lot of resistance from lawyers and that 89 amendment introducing 4 alternate dispute resolution mechanisms could not be implemented on account of resistance of lawyers, because the lawyers resisted, saying that this alternate dispute resolution will very adversely affect their professional income. It took so many years for the Supreme Court also to convince them finally by a judgment of famous Madras Bar Association, the Salem Bar Association, where the Supreme Court convinced them that this is an additional mechanism of dispute resolution. This is not going to affect you professionally, whereas this will only enhance your prestige of prestigious profession, and also it will have its own sources of income as well. Probably thereafter we took off. And we took off with, we had mediation, arbitration, conciliation, and conciliation, judicially involved conciliation, and also what we call Lok Adalat. Lok Adalats are, I'll start with the last one. Lok Adalats are cases where mainly we have settlements on compensation cases. Largely in all over the country, thousands of cases are settled on compensation cases, and petty disputes are also being settled that way also. Then next is conciliation. conciliation, unfortunately, has not picked up very well in India. I don't know the reason, because that as a mode of an alternate dispute resolution mechanism has not picked up. One reason is it is not clear. This is very vague now. Even now it's very vague, because judge involved or the judicial intervention on conciliation, how far is it is effective, how far it will be practical is one issue. And the conciliation rule, though we have something conceived in the Arbitration and Conciliation Act also, conciliation as such is not being taken forward much, though it is a very effective tool. Then comes arbitration. Arbitration has been the time-tested dispute resolution mechanism outside court, both domestically and internationally. But 95% of the arbitration awards are still being taken to courts by way of a challenge under Section 34 or at the execution stage. So, see, all these alternate dispute resolution mechanisms were introduced so as to reduce the workload in court and so as to reduce the time that is being consumed for resolution of disputes. But once you take a decision in the once an award is rendered by the arbitral tribunal, and if that award is being challenged and taken forward, well, what's the purpose in going for arbitration? It has become an additional litigation channel for the lawyers and the litigants as well. And it has become prohibitively expensive also. That's also something which we should not forget. And it has become time-consuming also, though after the new act introduced in 1996, the maximum time permitted is only 1 year with an extension of 6 months and 18 months. Still, it has become quite expensive and time-consuming also on account of various other aspects. So, people, or rather the litigant public, particularly in the corporate sector and industry sector, are slowly getting fed up with the arbitration. So then comes the significance or relevance or viability of this last method, which I am going to speak on, that is mediation. Mediation is a non-committal procedure, number one. It's very flexible. It does not have any statutory rules as of now. It's very flexible. It is confidential by its very nature of the proceedings, and is voluntary. So even in respect of pending disputes, you can have mediation through the intervention of court, or without intervention of court also you can have mediation and report to the court that we have reached a settlement. You can pass an order or a decree or a judgment in terms of the settlement which you arrived at. You can also have the intervention of court also to have the dispute referred to mediation for an appropriate center like the chamber which we have started now. A very model. I must congratulate the Andrup Onkar and the team and the chamber also for introducing the first institutional mediation in India through a chamber of commerce. So that's very beautifully done also. I'm quite sure something which starts in Bombay will pick up and will be a model for the across the country and internationally also. So the mediation you can have through the intervention of court also. And what is this mediation process? This mediation is a process of negotiated settlement. As simple as it is, a negotiated settlement. You can have your own negotiation between the parties, and the mediator only facilitates the litigants, the parties, to evolve solutions. Therefore, instead of the lawyer speaking, once you are into the hands of a lawyer and you are before the court, you hardly speak. You only witness what is happening in the court, and many a time your lawyer may not speak what you have instructed him. Many a time what the lawyer speaks may not be understood by the court, and many a time what the court imposes on you may not be an acceptable and a just order for you also. So in court we get a third party imposing an order on you. In arbitration also an order is imposed on the parties, whereas in mediation this is a solution evolved from the parties, and not only one solution, you have multiple solutions also. So you can have several options as far as mediation and a settlement leading there to is concerned. Therefore, the involvement of the parties and assisted by the lawyers is the wonderful process as far as mediation is concerned, because once the parties sit together, you will have a realization as to what is the interest and what is the underlying interest, and where lies the crux of the dispute, and what are the possible solutions for this. We call it underlying interest, then the options, then alternatives. These are the three methods we normally call. So what we need is actually a neutral person, a person with credibility as a mediator, and a person who is experienced also, because he's a facilitator. He facilitates the parties, facilitates what you call evolving a lot of solutions. Though he may not interfere and impose upon, that is the role of a conciliator. Conciliator actually gives you suggestions as to what could be the better solution, what could be the way forward, etc. Whereas a mediator doesn't give you solutions. He only helps you to, among yourself, between yourselves, to evolve solutions. But there is also a process called evaluative mediation. This is a facilitative process, evaluative mediation also. Evaluative mediation technically comes on technical aspects, whereas where the mediator who should be technically qualified to give you an advice as to what could be the best solution once the parties ask you, because the parties are not aware of the technical aspects, and whereas the mediator whom you have engaged is a person who is well aware of the technical aspects. So the parties might ask for an assistance as to what will be the best evaluation in a given situation. Where in that situation, it could be evaluative also. It could be clubbed also. This facilitative and evaluative process that could be clubbed also. And this arbitration also could be clubbed. In fact, I'm also an arbitrator after my retirement in Amber. I'm in quite a few arbitrations now. And I have very successfully tried this ARB, arbitration, mediation, arbitration. I can just cite an example. I had a case, I was a sole arbitrator in the Delhi International Arbitration Center in a dispute between two corporates. So, after my experience, it came out of my, I got a sixth sense. It's very easy to discern as to which case can be settled, which is a good case for arbitration, which is a good case for mediation. Out of our experience, we will be in a position to know. And I always had this sixth sense and the third eye to see where the problem is, and it can be solved also. So I told them, this is not a case where you should be spending time and money for a solution by way of an award. So why don't you try a mediation? I told them the possibilities before them also in a mediated settlement. I explained to them what mediation is. So they said, sir, we are very happy, we are only happy to mediate. So the moment they said mediation, I said, so as an arbitrator, technically I may not be in a position to mediate myself because I'm an arbitrator. Once, in case, in the unlikely event of the mediation failing, then it will not be possible for me sitting as a mediator and as an arbitrator also. They said nothing doing. Only if you sit as a mediator, we will cooperate. We don't want anybody else to know, because we know that you know what our problem is. So I said, I can assist you. So I took a different proceedings altogether, sitting in the same chair as what you call assisted mediation for a settlement. In a couple of hours, the whole problems were settled. We drew up a settlement. And on the basis of the settlement, I passed an award also. So on the second sitting of the arbitration proceedings, an award was passed. The whole disputes were settled. So there is no appeal. There is no revision. There is no further challenge. And both parties have won. There is not a question of one party winning, one party losing. In any litigation, other than in mediation and a settlement, either you win or you lose. It's very difficult to have a win-win solution. The best advantage of mediation is you have a win-win solution. Both parties have a satisfaction that we have won, and we have been properly understood, and we have won our disputes also. And the better advantage among corporates and industrial is that your relationships get restored. This is very important. In mediation, what is more important is, what is actually important for you, particularly, is restoration of relationship. Because your disputes are inter-corporate disputes or inter-industry disputes. You need to continue this relationship. It's not as if you fight and finish it off. No, you need to continue this, your relationships, your contracts, your commerce, your trade, your what you call further industrial growth need to progress through the same clients only. So restoration, maintenance of peaceful relationship is very important. When I read this mission statement also, it said it's a change, corporates for change. In fact, change for what? Change for development. What is development? Development is a new name for peace, actually. And there will be peace only if your corporate sector is litigation free. Once you are in litigation, there is no peace. No doubt about it, there is no peace. Your face is in difficult shape internationally once you are in litigation. There is no peace and there is no face also. So if you really want to have your good face shining across the world as a model corporate or a model industry, you need to have peace at home and peace inter parties also. This inter parties peace can be, disputes are no doubt about it. In the commercial world of today, disputes are bound to arise. I don't say likely to arise, they're bound to arise because there will be always a clash of interests as your relationships progress. For many reasons. I don't want to illustrate on those reasons also. They should, because it's actually a sign of growth. These disputes evolving in the process of trade is a matter of sign of growth also. Not always a dispute arising out of a failure of a relationship. No, it's a sign of growth as well. So once the disputes arise, the earlier moment, nipping at the butt, we call it the earlier moment you solve it, that's the best way you can maintain your communication, you can maintain your relationship, and you can have a peaceful growth among the parties also. So I would like to conclude here because we have been discussing with Mr. Deepak Parekh also, better than we talking to each other, because many people who are present here would like to know many things from us. So he also said he may not speak for more than 15 to 20 minutes, though allotted time is 30 minutes. So we can have a little more time for interaction. Thank you very much. I feel that the way forward for India in dispute resolution, particularly in the corporates, and I have been as a judge, I've seen hundreds of cases in my court being settled. Even the mediators fail also. I call the parties to my court and ask them what is the problem. And it's very easy to, once you analyze the problem, it's very easy to solve also. And there is hardly any case which went out of my court without being settled. In the Supreme Court, I had a tenure of 5 years and 8 months. I've seen hundreds of cases being settled in my court also. So the way forward is actually a mediated settlement culture being introduced in the dispute arena of a corporate and industrial sector, where you will have peace. It is less expensive. And it is non-committal also, you never have to commit, and it is confidential also. Even if the mediation fails also, you can go for other disputes also. And the mediator is bound to keep the confidentiality also. So this is all what I have to say as a preliminary, for the purpose of a preliminary discussion on mediation. Rest we will see the interaction section. Thank you. All the best. Jai Hind.